Most people think that if the police question you without Mirandizing you, that your answers are going to get kicked out in court, or that perhaps your arrest becomes invalid. Here's the reality when it comes to Miranda warnings. The Miranda warnings that we've all become familiar with, the right to remain silent, the fact that you have a right to an attorney, and that if you can't afford one, one will be provided to you, has become part of the American culture. We all know it from movies and what we see on TV. But what we see on TV is often a person getting arrested and contemporaneously being given those warnings. And it almost seems like those warnings are required anytime a person is arrested or anytime a person is questioned. That's not true. Miranda warnings only apply if two things happen at the same time. First of all, the person has to be in custody. And second, there has to be an interrogation that is started by the police. So if the police come to you and they question you, or if they invite you to their office and you go down to the police station and you talk to them, you're not in custody. You're simply there having a conversation with officers. And because you're not in custody, Miranda doesn't apply. In fact, it's common for officers to call folks who are under investigation and say, hey, I think you're a witness in a case. Would you come down to the station and talk to me? Or even, hey, there's been an accusation made against you. Would you come talk to me? Notice the officer is not requiring the person to be there. They're certainly not escorting them there in handcuffs, and instead is having the person engage in a voluntary conversation. If you're out of custody, Miranda doesn't apply, even at the police station. Second, there has to be an interrogation by the police. This means if you're arrested and put into a patrol car and transported back to the station and the police never ask you any questions subsequent to your arrest, well, that arrest has not prompted the requirement for Miranda to be read to you. Similarly, if you're arrested, placed in the back of a patrol car, and you on your own start talking, well, that's also not interrogation. That's you voluntarily providing information to the police. And once again, Miranda warnings don't apply. So in order for Miranda to apply, you have to be in custody and you have to be interrogated. So it's actually commonplace for officers to get back to the station, confirm who you are, and ask things like where you live without Miranda warnings apply. Similarly, Miranda warnings don't apply to things that are not testimonial. And that might be obvious, but a fingerprint is not testimonial. That's just something your body is providing. So they don't have to provide you with any warnings before they obtain that. The same thing applies to breath or blood tests. They don't have to give you Miranda warnings to ask you for a sample of your breath or blood, or even DNA, depending on what they're investigating. So the key takeaway here is Miranda only applies if you're in custody and you're being interrogated. So we made this video in response to questions that we got on previous YouTube videos, and we love getting those questions. We'd be happy to answer as many of them as possible. If you have a question about criminal law in Texas or any federal criminal laws, drop a question below and we'll be happy to answer them for you.